Vision, your hometown news and information station.
Welcome back. I'm Vincent Perryman and you're watching Legalese. Joining us on our show is Artie Bird of the Jones Law Firm. We are discussing Chapter 13 bankruptcy. Artie, before the break we were talking in generals and everything, and I think we've gotten to the point now to where once a client's come in and what are the steps that they can expect once they've hired you or any attorney in a Chapter 13 case?
Right. An important thing, once we've done all the groundwork and we've gathered all the information, we've prepared the petition, and we filed it with the court. The day that we file it with the court, and this helps a lot of people in a Chapter 13 and 7, an automatic stay goes into place. So these folks who fear losing their home or car or anything else, all foreclosure proceedings, all garnishment proceedings, court proceedings, any kind of collection activity has got to stop that day. Now, from the day that we file, we have to have what is called a first meeting of creditors, and that's generally about 3 weeks later. I think it can be up to 50 days later, but it generally takes 3 or 4 weeks, at which point the attorney and the debtor will go downtown to a meeting with the trustee. It's called a meeting of creditors. Oftentimes no creditors show up. The meeting is for the trustee to examine you and ask you questions under oath to see if the information you provided is true and accurate, if you listed all your assets and all your liabilities. The meeting with the trustee in itself, if everything goes smoothly, takes about 5 minutes. There's a lot of downtime and wait time down there. And that's the first court appearance that the debtor will have to make. After the first meeting of creditors, again hoping that everything has gone smoothly and everything's been provided, we'll have a confirmation hearing. Now, at that first meeting, of course, the trustee is looking at our proposal. They're looking at what we want to repay and how quickly and how much we're going to pay to the unsecured creditors. The trustee can correct that amount. If we've provided a low amount for unsecured creditors and the trustee sees a little bit more disposable income, they can increase it, and it happens sometimes. After that, we leave the first meeting of creditors with a plan that is sort of agreed on by all of us at that point. The trustee, the attorney, the debtor knows what they'll have to pay. And a couple of weeks after that, we'll go to a confirmation hearing where the court approves our plan. They will say, this is okay, this is feasible, looks like everybody's getting their fair piece of the money. And at that point, the debtor goes on their way making payments. Now, I say making payments, but most of the time and preferably, you don't want the debtor to have to write a check each month and send it to the trustee. It's hard to do. It's why people get in these spots anyway. It is hard to pay a bill on time for 60 straight months and never be late. So what will happen almost all the time is the bankruptcy court will get a wage assignment, basically. They will take the payments directly from your employer. If you have to pay $1,000 a month for the sake of simplicity and you get paid twice a month, they're going to take $500 out of each paycheck. Now, if you file jointly, you can split that up. If both you and your spouse have regular income and each of you make the same amount of money, you can take $250 here, $250 here, and pay off the whole amount each month. And it allows people to be successful in their Chapter 13 plans. And you want to be, for all the reasons that we talked about. People need to catch up on their house. People need to, make their regular car payments. People might just need to take all their debt and lump it together and say, I want to make a regular payment. And the wage assignment, it helps that. It helps people to be successful.
So now I guess one of the questions comes to mind with that is what happens if you get a raise? Can you pay your plan off quicker?
You can make payments. Now, technically, if you were to get a substantial raise, if your income went up substantially, the court can increase your payments. Now, the court's not sitting there looking at everybody's pay scale and 3% raises here and there, and generally that doesn't happen. But you can complete a plan faster than the 5-year time frame if you can make payments, if you're good with your money, if you budget appropriately. Sure.
And my guess is that, like most things with it, if you've got a monthly payment and say you paid more in 1 month, but then you miss a payment, you're not going to get credit for a portion of that month's payment.
You're not, and again, that's why the court loves to see, and attorneys love to see, you want to see it being taken directly from the employer.
Okay.
We don't want to have to wait for the debtor to go home and hit the 3rd, 4th, or 5th day of the month and say, oh no, I forgot to pay the bankruptcy trustee.
Right.
Because what they can do, and they will, is dismiss your bankruptcy, at which point creditors are restored to the rights they had originally. If you're still behind on your house at that point, if you haven't caught up the arrears, we're back to square one, and they still have their rights, their remedies, including foreclosure proceedings.
Can you get the 13 reinstated in that case, if they've missed a payment and get them back on track? Or?
You can. Let's say, for example, you lose your job during this time, or we have a joint bankruptcy and one of the spouses loses their job. So it's hard for this other spouse to make that full payment. You don't have 2 incomes anymore. There's a variety of remedies. One, you can ask the court to suspend the payments for 90 days. And the hope there is that in that 3-month time frame you can go find some work and continue making your payments. When, at least in my experience, when the court will motion for dismissal, they're good at giving the debtors a chance to make it up. Okay. If they start to see regular payments after the fact, they'll allow you to continue on in your bankruptcy. So there's remedies and there's choices that you can do if something bad does happen, if your payment decreases, and you can even modify your plan after confirmation. You can get your payments decreased for things of that nature. So okay. You're not totally, out of it if you miss a payment.
Okay, that makes sense. When we return from our break, we'll talk more with Artie Bird about Chapter 13 bankruptcy. Please stay with us.